So Darren, as a first question we've got here, probably one we could expect that we're going to come our way. How will the role of Commissioner be different next year under the Work Health and Safety Act compared to the Occupational Safety and Health Act?
Thanks, Ian. So yeah, good question to start. The Work Health and Safety Act has kept the WorkSafe Commissioner and identified the WorkSafe Commissioner as the regulator. The regulator will have responsibility across all industries. So currently, the WorkSafe Commissioner is responsible for general workplaces. Under the WHS Act, the regulator will have responsibility across not just general workplaces, but petroleum and also mines. So that is a substantial change. Having one regulator regulating work health and safety across all industries is a really important change under the WHS legislation. So for me, that's probably the most substantial change, and will increase the role of Commissioner quite significantly.
So as you said, there's quite a few changes coming just with the amalgamation of those functions. But like all sorts of reforms, the WHS reform will bring with it some changes and some things that are remaining the same. And I guess that provides us perspective of talking about the issue of workplace safety, which is, as you've said, is really important, and the expectation that people can go to work and come home safely each day. With the heightened consciousness around workplace safety while this reform is coming into place, do you see it providing opportunities for the regulator?
Yeah, there's quite a few opportunities from my perspective. The WHS legislation for WA will bring Western Australia into alignment with all the other states and territories bar Victoria. So we will have the same legislation as all of those harmonised states. So that's really important. We have a lot of interstate workers that travel into Western Australia and work in Western Australian workplaces. So having that standardised law, I think, is really important. The officer provisions in the WHS legislation, I think, is also really important. The due diligence provisions, which place an obligation on officers to understand the business, understand hazards, and put in place controls to manage those risks in their workplaces. Again, that clarification about those duties, I think, is really important. I also think the requirements or the provisions around enforceable undertakings is an important change, and will present lots of opportunities as a regulator to look at other options to try and achieve compliance across Western Australia. So enforceable undertakings can be entered into where there is an alleged breach of the Health and Safety Act. The regulator can enter into an enforceable undertaking, and the types of arrangements that can be put in place there, I think, will assist greatly in trying to improve health and safety across all industries. So just a couple of opportunities there.
So it's great that it's bringing those opportunities. So with those opportunities, obviously there's a move from where we are now, you know, the WHS Act, the Mine Safety Inspection Act, and the various petroleum acts that provide for petroleum safety, and we're moving across to the work health and safety regime. What's the sort of process for making that changeover from the current regime to the future?
Yeah, so a lot of work currently underway to prepare Western Australia for the implementation of the work health and safety laws. A lot of work being put into preparing our inspectors and the department to be able to implement the WHS law. The changes that will come in with WHS, I think, will take a little bit of understanding. We're going to need to do quite a bit of work to inform industry about some of those changes. Of course, a number of provisions that currently exist will continue to exist under the WHS regime. So again, making that information available to industry so that they understand their obligations. Yeah, a lot of work going into that. Of course, to do that, there's a lot of material that's being produced. Today's webinar is another example of the sorts of things that the department and WorkSafe are doing to alert industry and workplaces about those changes. and we'll get through a few of other questions in relation to some of the information, but quite a lot of work going on to be ready by January 2022.
Yep, so there's certainly lots of work going on, and you talked there about information. So I'm going to approach my question here. I suppose I'm going to indulge myself a little bit here. Is codes of practice. So we've currently got lots of codes of practice in Western Australia, and that they're going to need to be changed, I guess. So what sort of work's happening in relation to codes of practice to get us ready for next year?
Thanks, Ian. So a lot of work being done on codes of practice. So there's two types of codes of practice that have been focused on recently. West Australia has quite a number of codes of practice, and of course Safe Work Australia produce a raft of material, including a range of codes of practice. So the Commission of Occupational Safety and Health, in conjunction with myself and also the department, have been looking at those codes of practice, identifying which codes of practice are still relevant from the WA context, and also looking at the Safe Work Australia codes of practice, and looking to amend those codes so that they reflect the WHS Act, and the intention is to have those ready for industry to be circulated and to explain the requirements for health and safety under the WHS regime. So a substantial amount of work, but the department's been working headlong on that, and hopefully that will be out on or around about the time that the legislation is proclaimed.
Okay. So just to remind everybody out there to get your questions coming in. So we've got a question here from someone who's just sent it in a few minutes ago. Their question is, will the new WHS apply to even small companies who engage just a few people, e.g. a family business?
Yeah, so good question. So I might start with a quick definition. So the WHS legislation talks about a person conducting a business or undertaking. Of course, the Occupational Safety and Health Act has definitions that relate to employment arrangements that aren't necessarily contemporary anymore. The WHS Act has a term referred to as a PCBU, and so a PCBU would encapsulate those small businesses. So a small business would be captured under that definition, and there would be obligations on the WHS Act.
So I guess that's a reminder to people who are out there who are perhaps running a small business to get on and get onto our website and nominate for other work health and safety sessions during Safe Work October, and that'll help them get some more information on what it might mean for them coming up. So we've got another one here. Obviously, there's lots of things we have to do in terms of the transition from now to the future. We've spoken about that a little bit already. We've got a question here from somebody who's interested in what resources will be made available to small businesses to assist them with attaining and maintaining compliance with the changes. So again, a bit of a similar theme, a small business, and interested in how are we going to assist them?
Yeah, so small businesses are an important part of the West Australian workplace landscape. I just talked about the codes of practice, and you've mentioned the department's website. So there's a lot of information on the department's website that is made available for those small businesses, and it's written in a way that it is digestible and easy for those small businesses to read, pick up, and understand what their obligations are. I should also mention that at the national level, there's a raft of documents and information that is available, produced by Safe Work Australia. So the department, WorkSafe and Safe Work Australia work on producing that information, and we are acutely aware of the different forms of businesses that exist out there. Small and medium enterprise are a large part of the workplace, so our information is always considered in that context, and we try and tailor it so that it is easy and readily available for them.
Okay, that sounds good. So a key part of the regulator functions is our inspectors.
Yep.
So in the current world, we've got inspectors under the WorkSafe inspectors under the WHS Act. We've got mine safety inspectors, and we've got petroleum safety and various others, major hazard experts. And as we're moving to one Act, and we'll then have one Inspectorate, I guess we have a question here around inspectors, and specifically the one that's been asked here is, will WorkSafe inspectors be visiting mine sites?
Yeah, so that's a regularly asked question. So under the WHS legislation, inspectors are appointed by the regulator. My view is that once we move into the WHS regime, the inspectors that are employed under WorkSafe will predominantly operate under those ANZICs. So there are codes that we operate to, the ANZIC codes, Australian New Zealand industry codes. So those ANZICs dictate where our WorkSafe inspectors go. And likewise, our mines inspectors have been employed and recruited to conduct their activities in the mines area as well as petroleum. I think initially there'll be we'll operate under that existing regime, but over time there are disciplines, there are activities where there is inspectors in both mines or in WorkSafe mines and also dangerous goods, and where there are synergies and like practices, I think there'll be opportunities to look at how we utilise our skills and expertise that exists within the Inspectorate and ensure that our inspectors are able to provide a good quality service to the West Australian public, regardless of where the workplace is.
Okay, sounds like there's lots of work ahead for us to get there. Now, this next question we've got from someone is a very interesting one. It touches on the independence of the Commissioner. So the person's asked a very good question around how will the Commissioner work with demurs under the new Act, and what sort of structures are going to be put in place, and how are we going to report and those types of things. So obviously they're interested in your role as the independent Commissioner and how that's all going to work in the future.
Yeah, so in 2018 I was appointed as the independent WorkSafe Commissioner. So that arrangement's been in place for a number of years, and currently I work very closely with Department of Mines Industry Regulation. Of course, Ian beside me. We work regularly on a range of issues. So the department assists me in discharging the functions that I have currently, and that will continue under the WHS regime. I think it's probably important to note that there are a couple of other statutory positions that will continue on under the WHS regime. So State Mining Engineer and Chief Petroleum Dangerous Goods Officer. So those two positions will continue under the WHS Act. They have an extraordinary amount of experience, knowledge and experience in their fields, and I'll need to rely on that knowledge and experience to be able to ensure that West Australian workplaces are safe and healthy. There's a collaborative arrangement that's currently in place, and I expect that that'll continue on under the WHS regime.
Okay. So more of the same, but a little bit different.
Same, different. Yeah.
Same, different. So the world moves on. So the next question we've got here is obviously an area where people are going to be very interested in terms of the regulations and their release in January 2022, yep. Which is coming up on us fairly quickly. The question here is really about the phasing in period in relation to the regulations and how we're going to work with employers to achieve compliance, recognising that some things will be hard to achieve on day one. So
yeah,
thoughts there, Commissioner?
So yeah, good question. The harmonised legislation and regulations allow for transitioning of specific requirements in the Act. So the government is currently working on drafting those regulations, and I'll leave the announcement and the details in relation to those regulations to the government. But I know that there are transitional arrangements that will be accommodated for under the WHS regulations. Those transitional arrangements will allow for West Australian workplaces to be able to understand their obligations and provide time to be able to comply with those. I might just quickly talk about, there's a document that I aim to produce before the legislation is proclaimed, and that is a statement of regulatory intent. So the statement of regulatory intent will outline the approach that we will adopt as a regulator. So our inspectors and myself as the regulator will seek to provide an information and educative approach to our regulatory duties once the Act is proclaimed, and that will again assist industry understand their obligations have our inspectors and the department providing information so that that they can get up to speed and understand how they meet their duties.
So that statement of regulatory intent, that sounds like a really good document. It's obviously got an education focus at the front.
Yep.
But obviously, if we encounter something that's very egregious, then as a regulator, we're still going to have to take action. Is that?
Yep. So it's a good pick up, Ian. So the statement of regulatory intent allows for inspectors to be able to work with the duty holders at the workplace and have the discretion to be able to identify where there is a significant risk to workers. Of course, we don't want workers being exposed to hazards and have them potentially injured or harmed. So our initial step will be to provide information education. However, where an inspector comes across a situation that is a significant risk, then it is available to them to use the powers that are available to them under the WHS Act. So important provision. Of course, where there's an incident, we will always conduct our investigations thoroughly and ensure that we try to identify what's gone wrong in those circumstances. So in that context, where there is a serious injury or fatality, we will approach that in the same way we currently do. So the regulatory intent allows for some flexibility in how we approach our regulatory duties, and again, to work with industry to explain to them how they can meet their duties.
So quite a balancing act for the regulator along the way. Same for the balancing act for all of industry as they move from the current regime to the future regime. So just a comment, I suppose we've seen with the questions coming through, we're getting quite a few in respect of the legislation. Happy to take some of those, but just remind everybody there are specific sessions on the legislation later in the month to register for those, and those will be where you probably get most of those answers. We'll probably try and deal with some of those legislation questions today, so we'll just see how we go. But just returning back to the codes of practice, we've got a question here about does this provide an opportunity for us to simplify, the content of those documents, and whether it has a benefit for simplifying business operations for people and still delivering that desired outcome of workplace safety.
Yeah, so I mentioned earlier the Commission of Occupational Safety and Health. So that commission is a tripartite body that has responsibility for developing codes. That body will continue into the WHS legislative arrangement come January 2022. That body, in conjunction with the department itself, have done that review. So the members of that committee have looked through the codes of practice, identify those codes that we want to keep from that are currently in place for Western Australia, and those codes at the national level that have been produced by Safe Work Australia. So that process has taken quite some time and quite a lot of work that's been put into that, and the intention is to have those codes out for industry in preparation for the WHS legislation. So in terms of simplification, the codes, as I say, have been developed to explain what the duties are, try to explain the hazards and the risks, and importantly, how they can be controlled. So I think the work that's been done has been quite good and will help industry.
Okay. Very good. So we're sticking on a bit of a theme here. The next question is still on codes. So You're not going to escape the codes of practice at the moment yet, Darren. This question is, when will the release of the updated codes of practice occur?
Yeah, so I think the government's intent is to have the legislation and the regulations proclaimed by January 2022. So currently they're being drafted. The regulations, I should say, are being drafted, and once that's completed, they'll go through the houses, and hopefully before Parliament ceases for the end of the year, the legislation, the regulations will be proclaimed. At around that time, the codes of practice will also be endorsed and made available for the public. I should mention that the codes of practice are already on the website. In the WHS legislation, there is a provision that allows for the transition of West Australian codes of practice to be taken across into the WHS legislation. So there are a range of existing codes that will be transitioned over. So there won't be new requirements. Industry won't need to learn about those existing codes under the WHS regime. I think that's a really important point for industry to understand.
Yeah. So that is a really good point, because a lot of things are staying the same. Lots of the outcomes that are intended for workplaces today are the same intentions for the future, you know, that be safe, and a lot of the practical measures will stay the same, won't they? Yeah. So the next question was sort of along the lines of, again, sticking with codes, but also exploring the regulations in terms of our education processes. I'm assuming we've got some things planned for getting out there and educating and communicating with people.
Yeah, so the department's done quite a bit of work there, and Ian, you've obviously been a significant contributor to the development of a lot of that material. So I can't talk specifically about the regulations in terms of the detail, but there is a raft of information that will be produced and published on the website. There's a range of media activities, so these types of webinars will go into some detail. That'll be made available. The benefit of the webinars and using social media is that it is readily accessible for people. We do know that people access their information on their mobile devices, so the information is being produced to be able to be disseminated by those mobile devices. So where possible, producing information that can be sent out to all the various workplaces across Western Australia in a medium that suits West Australian workplaces.
Yep. Very good. So Darren, we've spoken previously about the approach of the regulator and your statement of regulatory intent. So I'm just going to go back to that topic for just a moment. We've got a question here. I think we didn't really say when it was going to be released. So the question we've got now is around when will that statement of intent be available?
So the statement of regulatory intent, we're doing some consultation in relation to that at the moment. So still finalising that. I will release that statement of regulatory intent again on or around about the time that the Act and the legislation is proclaimed. So there'll be a release of obviously the Act, the regulations, codes of practice, and we'll also release the statement of regulatory intent. So it will operate from January 2022 for a period of 6 months. So that sort of aligns with a number of our reporting obligations in terms of statistics and the like. So our statistics are calculated across a financial year. So having a statement of regulatory intent in place for 6 months means that we can use that period to provide information and education to industry, noting that we'll be switching from Occupational Safety and Health Act to the WHS Act. So there'll be an anomaly in terms of this reporting year. So the statement of regulatory intent fits quite nicely in the middle of all of that, and hopefully will assist not just industry, but also assist the regulatory work that we need to do, and allow our inspectors to engage with workplaces and explain what those new requirements are.
Okay, so it's interestingly, you just mentioned there the switch over from the Occupational Safety and Health Act and the Mine Safety Act to the Work Health and Safety Act. And that sort of flows into this next question we've got, which is around investigations and prosecutions. As we know, things are happening today, and it takes us some time to work our way through to understand what occurred, and might take us into next year. So will current investigations and prosecutions continue under the current legislation, or will they be moving across to the Work Health and Safety legislation?
Yeah, that's a really good question. So where an incident occurs under the current Occupational Safety Health Act or the Mine Safety Act or the Petroleum legislation, that incident will be investigated in accordance with the current arrangements. So I think it's probably important to note that the current requirements, the current statute under the Occupational Safety and Health Act is 3 years, and that is a substantial shift under the WHS legislation. So the statute reduces under the WHS legislation. But in essence, to answer the question directly, an incident that happens under the current legislative arrangements will be investigated in accordance with that, and post January 2022. And if there is an incident in January 2022, the WHS provisions will prevail. So that's how that'll work.
Yeah. So I guess that gives confidence to people that we're not going to go about shifting the goalposts.
Yep.
You know, what they're expected to comply with currently will be the benchmark will be measuring them against if there's something that's occurred in their current environment.
Yeah, that's correct. And just to perhaps elaborate a little bit further in terms of the statute, that was something of some significant discussion over the past couple of years, and a number of families have spoken about the time that it does take to conduct investigations, and the WHS legislation reduces that by 12 months. And there are some other provisions in there that I think are quite helpful in terms of families that are affected by serious incidents and workplace fatalities. So they are really important provisions. It places an obligation on us as a regulator to conduct our investigations in a faster time frame. And we know that when there are those types of incidents, that the length of investigations that currently exist does cause concern to family members. So I think that's a substantial improvement under WHS legislation, that we will have a reduced statute. So I'm looking forward to that.
Okay. So lots of changes all about, some for the regulator in terms of how we go about our business and the time we take, but also changes for industry and others working in the WA workplaces. So we got a question here about inspectors and the role they're going to have in terms of going out and conducting sessions to educate business on the work health and safety legislation before the laws come into effect.
Yep.
So any views in relation to the inspector's role around the education part of the introduction?
Yeah, so I know that today there'll be some inspectors, and very happy that we're able to talk to them as well as everybody else out there. Our inspectors play a really important role in assisting industry understand their obligations. So currently and into the future, inspectors are there to provide information and assist industry understand their duties. And of course, where they identify issues, they've got some powers there that enable them to issue improvement notices or prohibition notices and the like. So over the past couple of months, WorkSafe inspectors and mines inspectors and petroleum inspectors have all been working really hard, obviously with the department, to look at our systems, look at our processes, and also some of our training material to equip our inspectors with the skills and knowledge that they need to be able to go there and educate industry. So yeah, inspectors have a really important role currently, and that will continue on under the WHS legislation.
Okay, so with the inspectors and lots of other people inside the organisation, you know, working hard to get things done and improve the place, and how we go about educating people. I guess there has been the budget announcement in respect of resourcing for the agency and WorkSafe and other parts of the safety regulation delivery. And this sort of goes to the next question about, will there be more people checking on safe work environments and offering advice?
Yeah, so there's been a number of increases to the resources over the past couple of years. So going back to 2019, there's an increase of 6 inspectors and then an additional 21 inspectors. The government in the current budget has announced increases in not just inspectors, but a range of other support people. So the department has got increases in FTE in areas for policy and education, in customer service, and also legal support. So I think they're really important increases and additions to the department, and I think an important part of our focus needs to be on the proactive prevention and information and education. And so those additional resources that have been committed by the government in the current budget submission, I think are really important. And obviously with the change in legislation, quite a lot of information is going to need to be provided to industry and industry will have the opportunity to be able to contact the department and ask questions and seek information. So those increases, really important to implement the WHS legislation.
Yes. So now we're just moving on to a completely different sort of topic here, Darren, and I was probably going to paraphrase this one a little bit,
okay,
because I'm rolling a couple of questions here together. There's one here around the role of individuals and the responsibility of the Work Health and Safety Act imposes on them. I guess that might be, say, due diligence for directors and those sorts of people. With that accountability, do you feel there'll be less people prepared to take on those sorts of roles, or do you think it's part of business as usual?
Yeah, so it's interesting. So there's a few new requirements, as I mentioned earlier. So the officer provisions are new requirements. They're new to WHS for Western Australia. They're not new for those other harmonised states. And of course, the due diligence officer provisions are extracted out of the Corporations Act, so they're not actually new for enterprises that have senior leaders and directors. So, but nonetheless, they'll be new for the WHS regime in WA. And of course, there is a definition for workers. So the WHS legislation talks or provides greater detail about workers. I don't think that those new requirements will detract from people either commencing new businesses or continuing existing businesses. From my perspective, the WHS legislation brings us in line with everywhere else. It provides some clarity about some of those roles, and I think will assist a lot of businesses understand their duties.
Sounds like a good move forward. So, Darren, we've got a few questions here on a common topic. Now, I'm not certain whether you want to tackle it, because I know there's lots of work happening around volunteers at the moment.
Yep.
Maybe it's one of those ones where better off, it might be covered in one of the later webinar sessions. So again, just a reminder to people, if you've got legislation-specific topics, perhaps to talk to those sessions to get the answers. But certainly we've got one here, or more than one really, around volunteers and how the work health and safety laws apply to them compared to the occupational safety and health laws. Now, that's my paraphrasing. There's a few questions about bushfire volunteers and the like, but maybe we just roll them together into that sort of question.
Sure. So I think the start point is that volunteers are an important part of our community. So not just bushfire volunteers, there are volunteers across a range of industries. The WHS legislation has provided some details, including the definition of a worker is a volunteer. There's been a lot of discussion around that across Western Australia. Of course, that's something that's specific with the Bushfire Association volunteers. So I fortunately had the opportunity to meet with a number of those people, so the association leaders, as well as agricultural leaders, and also emergency services leaders, to talk through that and provide a better understanding about those requirements. From my perspective, I think the additional detail assists in making make it clear that volunteers are important. There's a specific exemption in legislation that's relevant to volunteers. And importantly, we've got some guidance material that we've drafted and will be released prior to, a proclamation that explains the role of volunteers. So there's quite a bit of information. I know there's been some concern, and I think with last week there's quite some good discussions with those industry leaders, and yesterday I put out a media release to talk about those discussions, and what that means is we'll continue to produce information so that we can explain the role, explain the regulatory role, and also obviously protect the volunteers, which is what the primary importance of the legislation is, about making sure that all workers, including volunteers, aren't impacted by doing the work that they do.
So now, correct me if I'm wrong here, Darren, but the way I see it is that perhaps the volunteers are already covered under the occupational safety and health regime as it currently stands, and that the work health and safety regime is doing much the same, but perhaps a little more overtly.
Yeah, so it's provided some further detail. I think it's provided some clarity, but equally there's been some concern about it. And so we've moved quickly to engage and consult with industry to talk through that, to try and understand the concerns, and we'll continue to produce information to assist them.
Okay. Sounds like a good step forward and part of the overall transition that we're going through. So again, we've got another fairly specific question here around section 26A of the Act. So again, just remind people there's going to be a session on the Act. But there's probably a couple of questions here if I'm looking down the list. One around safety professionals and the minimum training that they'll need to be able to continue to practice, and another one around what do service providers need to be fully aware of when providing these services to business. So you've got some thoughts there that you might just be able to
Sure.
whet their appetite for the bigger session that's coming later in the month.
Yeah, so look, it's another area where there has been quite a bit of interest, and in some areas some concern about those provisions. I think it's important to note that that specific requirement in legislation is already a duty under the current arrangements. So under the WHS arrangements, it becomes an explicit duty. We will put out some information specifically in relation to the requirements of 26A, and I mentioned the statement of regulatory intent. Again, I've covered that off in the statement of regulatory intent to explain how we'll approach that as a regulator, and again provide some assurance to industry about those provisions. So hopefully that will alleviate the concerns and ensure that where WHS services are provided, that they can continue to do that, because what we do need is that industry does obtain the advice when they need it, and that advice is quality advice.
Okay, sounds like another good move being made by the WHS, and a lot of work by yourself and the agency to help people get across that understanding. So you've talked quite a bit already in respect of the move from the current regime to the future regime, and I'm not certain whether we've perhaps covered this question already, but there's another one's come in, so maybe people are still wanting a bit more information about it. So what sort of transitional provisions are going to be there, and for how long?
Yeah, so that's probably a bit of a detailed question that might be a bit difficult for me to answer right at the moment. As I said earlier, the government is currently working on drafting of the regulations, which includes the transitional arrangements. And I know that that is a really high priority for government. There's been quite a lot of work done very recently to progress that. And the intent will be to release that as soon as possible. So in terms of transition provisions, those requirements are allowed for under the WHS harmonised legislation. There'll be some specific provisions that the government will make a decision on and announce in due course. Okay. Something else.
Something else. So this one is complete. If this is the first time we've had this topic coming up today, but it's a good topic to cover. It concerns safety and health representatives. Yeah. I mean, they're a very important part of the current regime. Yep. And be a very important part of the future regime too, I imagine. Yep. Is there going to be a requirement for them to undergo full training as the new laws come in, or are we just going to transition them across?
Yeah, so health and safety reps are a really important part of our safety and health framework, and I know that both myself and the department, as well as the Commissioner of Occupational Safety and Health, talk about health and safety reps regularly. So we're regularly talking about how we provide or how we can provide support to health and safety reps. And of course, how we can encourage more health and safety reps to take on the role. The health and safety reps currently have a requirement for training. Under the WHS legislation, there will be a requirement for training. I can't talk specifically about transitions, but I think the emphasis of health and safety reps and the importance of health and safety reps has been recognised in the WHS legislation, and will continue to prioritise them under the WHS arrangements.
Yes, certainly a very important part of the schema, and yeah, it'd be good to see them continue on. And I guess Darren pointed out there, we are always looking for opportunities to improve the number of safety and health reps in workplaces. So Darren, we're just going to go back to the codes now. Again, it seems to be a very popular topic today.
Interesting.
One of the questions here relates to the standards and whether they're going to be freely accessible.
Yep.
I guess that's a very hard one to delve into because there's a commercial arrangements that, the standards are owned by Standards Australia, so access to them is governed by their commercial requirements. Then certainly we make them available via our library if people want to come into the WorkSafe library. But I guess this question sort of goes to the use of the standards in the codes. So are we retaining a lot of the standard requirements in the codes of practice?
Yeah, so there's some detail, obviously, that would need to be talked about as far as WHS regulations are concerned. I think the important point to note is that under the current arrangements, there is reference to numerous Australian standards. The WHS legislation and the regulations, the harmonised regulations, doesn't refer to the same volume of Australian standards. So there will be a reduction in terms of references to the standards in the regulations. And that's a deliberate intent and aligns with the rest of the country. So as far as our regulations are concerned, there won't be the same reference and reliance on those Australian standards. Of course, there's other ways that we can spell out the requirements to meet health and safety standards, so codes of practice being one of those, obviously guidance notes and other guides. So we'll continue to produce that material, but in principle, the harmonised regulations will see a reduction in reference to Australian standards.
Yeah. So I guess that's quite a good move, really. I guess in the sense of providing certainty, the law is meant to provide certainty. So if we're not relying on standards which can change, then people do have certainty through those regs.
Yeah.
And again, the codes of practice are issued by the regulator in conjunction with the commission. So again, providing that certainty to everybody around what's required to be done.
Yeah, so our current regulations do refer to a lot of Australian standards. That does become cumbersome and difficult, particularly when Australian standards change, so the versions change. So trying to keep up with that has been a problem over a number of years. So not having those references will be a reduction in terms of the regulatory burden. I think the important part from my perspective is to ensure that where there are technical requirements or where there are controls that are spelt out in the Australian standards, that we don't diminish the standards under the future arrangements, and we can accommodate for that, as I say, via a range of means. We can consider, obviously, whether or not they are picked up in the regulations or codes or other guidance material. So I think the important bit is to make sure that we maintain the safety standards that we have.
Certainly do. We don't want to see any of the standards dropping. We want to continue to see people operating safely and going home each day after their day at the office or whatever their workplace is.
Yep.
So this next question we've got here sort of takes us back to directors and the due diligence aspects and their responsibilities. There's a question raised here probably from someone who's in one of these sorts of teams around what support we're going to provide to the health and safety teams to increase the awareness of senior leadership's team members around their responsibilities and their accountabilities. Have you got any thoughts on that? It's a very specific question, but
yeah,
you might have some thoughts there.
So looking at management responsibilities across a range of hazards is something that we've been talking about probably more recently in relation to psychosocial risks and mental health. So in terms of the material that we've been producing, both at the national and the state level, so particular codes of practice and guidance material, spelling out what managers can do to better deal with management of mental health of their workers. So a concerted effort has gone into developing that material and being considerate of the duties that managers and supervisors have, and importantly some guidance on how they can provide a safe workplace for their workers in a mental health context. So that's just an example of where there has been a shift in focus and trying to provide information and guidance to industry for managers and supervisors. That exists in a few other areas as well. So, talking about recently in Western Australia, the codes of practice that were developed for occupational violence and aggression, as well as workplace behaviours. So, again, both here and nationally, developing material that looks at the duties for all the way through from the employers all the way through to the employees.
Okay, so Darren, I'm jumping around here a little bit, so I'm putting you really on the spot, so hopefully it's not too difficult for you. So the next question I'm interpreting as being about enforceable undertakings. The person's used a remediation process. So that's probably my interpretation of it. But the question was, how will the agreed remediation process versus a prosecution work for companies who have breached the regs?
Okay, so the way that enforceable undertakings are intended to work is that there needs to be an allegation that the WHS Act and or regulations have been breached, and the enforceable undertaking can be entered into with the regulator. So those provisions are in the WHS legislation. I think from my perspective, we currently have enforceable undertakings in our current legislation, but to my knowledge, we haven't utilised those provisions. So the new requirements under the WHS will provide us some really good opportunities to work with industry to identify where we can enter into enforceable undertakings. Obviously, we would need to conduct an investigation and identify where there's been a breach in order to enter into an enforceable undertaking. And the enforceable undertaking would need to be, a substantial commitment by the PCBU, and where those conditions can be met, then we would enter into an EU. So, looking at the other states, some states have been slower than others on the take-up for enforceable undertakings. I've looked around at various other regulators, and so there's been some really good innovative ideas that have gone into the development of the EUs, and from my perspective, I think they'll be really important to advance health and safety in Western Australia. So I'm looking forward to that coming in.
So I think you actually mentioned those as one of the opportunities at the outset. So it's a real opportunity to make a difference.
Yep.
I guess that's probably one of the things that prosecutions don't always result in a difference. And I guess the key from our perspective is to see the changes made that deliver safety in workplaces rather than just a flat-out penalty.
Yeah, so I think what industry would appreciate is an understanding how that's going to work. So we have drafted a raft of policies. We currently have prosecution policies and so also enforcement policies. So they will pick up the new requirements under the WHS Act and spell out how those EUs will be entered into. So again, that information will be made available through our website and spoken about via various forums, including webinars similar to this.
Yeah. Very good. So now we've got some other very specific questions here. There's one that's particularly about mining sector. So probably just probably an observation here. I think it's probably into too much detail for today's session. So what we might do with this one, which relates to the requirement to have a single safety management plan as opposed to allowing contractors, etc., to have their own plans and update those. I think we might just take that one and put out some information on it, because it is a fairly detailed one to get into. So we might just park that one there for now. Look, we've got a few minutes left, so we'll try and get through a few more questions before we need to go and leave people to get back to their day in full. Some questions here in relation to the availability of the regulations, again, sort of when they can be seen, probably something for us to deal with later on down the track. There's one, we're going back to here, a question around health and safety professionals.
Yep.
And the difference of a health and safety professional who is working within a business versus a health and safety professional who is perhaps outside the businesses but providing services. Do you see much difference in those sorts of arrangements?
Yeah, I think that question is getting at the requirements for Section 26A.
Yeah.
So there is a distinction between the provision of those services both within a PCBU and outside. So as I say, we'll put out information explaining how that 26A works and provide some assurance via the statement of regulatory intent.
Okay. Now, I've got a question here that's probably is quite topical. It's always it's part of the new environment we've been living in for the last 12 to 18 months, and COVID-19 and the effects it's been having. Has that influenced us much in respect of how we've developed the WHS Act and regulations?
I think the work was largely done prior to COVID arriving on our shores. So WHS Act was originally consulted with way back in 2009, I think initially enacted at the Commonwealth level in 2012, and West Australia has obviously been looking at it for a number of years. So all of that work has been done prior to COVID. So I don't think COVID has necessarily influenced or affected that much at all.
Yes, so a lot of it was done back in 2010 and 12 and
10, yep.
10, and
yep.
So yes, well and truly pre-COVID, but
Yep.
I guess that is just a reflection of the environment we're in now, and it's sort of front of mind.
I'm glad we spoke about COVID. I was waiting for a COVID question.
Well, I left it to the very end, so you don't have to worry about it too much, Darren. So we're just going back to health and safety reps here. This is probably one we've probably covered a little bit already, but so we've got a person here who's a health and safety rep. They've been elected 2 months ago, and they're just interested about how they're able to carry out their duties going forward, pre-completing the training, and will they still be able to do what they've been elected to do?
So the short answer is yes. So obviously there's a current training obligation that would exist for that safety and health rep, and that safety and health rep, obviously assuming that they're duly elected and all the paperwork, etc., has been done correctly, they would be able to fulfil their duties once we move into the WHS regime.
Yeah. So we've been getting lots of material coming through, so it's been great to have everyone contributing their thoughts on Slido, and no doubt there's a whole bunch of questions that we haven't had a chance to answer, Darren. So
it's gone quick.
I'm sure we'll capture those and get some information out there and use them for even the development of our frequently asked questions material put on our website for people. There's one last one here, I guess I'll just cover off on as a bit of a observation, I suppose, that you know, we're making changes for the petroleum sector onshore, and obviously there's things that may or may not be aligned to offshore with NOPSEMA. I'm guessing that you'll have interactions with your co-regulators on a regular basis?
Yeah, so that's a really good point. How regulators operate has been a topic of conversation through various inquiries over the years, and from my perspective, I think it's really important that as a regulator we have regular interactions. So there are numerous regulators. So NOPSEMA is obviously one of them. There is Australian Maritime Safety Authority, Rail Safety, obviously Comcare. And there are other state-based agencies, obviously such as WAPOL. So from my perspective, I think it's important that we do have a good working relationship with all of those agencies, particularly where there are incidents where there may be some jurisdictional overlap. So it's important to have those relationships in place, so when an incident occurs, we are able to conduct our work as efficiently as we can. And so it's been quite a bit of work done to engage with them, and that will continue on under the WHS regime.
So regulators often get together and have discussions about common areas of interest.
Yep.
Yeah, and just work together to deliver a seamless situation as possible.
Yeah. So just an extension of the conversations that we have, I just mentioned a couple of other regulators. At the national level, there's a group called the Heads of Workplace Safety Authority. That group it constitutes all of the safety regulators from each state and territory. So we do meet regularly, and the idea there is that we are sharing information that we have about the functions that we perform, and where possible, try to provide some consistency in terms of how we deliver our regulatory functions. So Hauser is a really important group, as well as Safe Work Australia. Both of those groups bring us into the conversation at the national level and allow us to keep up to date with what's going on with all those other states and territories. And of course, importantly, allows us to develop relationships so that we are able to work together when we need to.
I guess that's really important too for people who've got businesses that go across jurisdictional boundaries, that what one regulator is doing across the border is not that different to what we're doing here as well. So
yeah, that's right. And there are occasions where there is questions about jurisdictional overlap. I should say that the WHS legislation does provide an opportunity in this regard. So there are specific requirements there that allow safety regulators to be able to work together. So again, another important opportunity and benefit with the WHS legislation.
Yeah, very good. So the next one here is probably a question I can probably answer. So you can take a breather, Darren.
Very good.
Just give you a little rest at the very end. Worked hard so far. So the question here was about the webinars and their availability down the track. So certainly today's webinar and others are going to be run during Safe Work month, October, will be available as recorded sessions on the WorkSafe website. Not certain how quickly they'll get up. There's probably obviously a whole lot of backroom production stuff that has to happen that's beyond me, but that will enable us to get these materials up there and people will be able to refer back to them or even use them in their workplaces as an educational resource. So certainly we'll get onto that as we get these webinars completed. So I think, Darren, that pretty much brings us to the end of today. So firstly, I'd just like to thank everyone for joining us this morning. Thank you for all your questions. I trust that today's session has been useful in terms of setting the scene. I think it probably has, Darren, from my perspective, setting the scene so that when people log on and register for the other sessions on the specifics of the law, they'll have a bit of background about how the regulator is going to approach it all, and that's always very good. So from that perspective, I'd like to thank you, Darren. WorkSafe Western Australia Commissioner is a very busy role on, and I think we just really appreciate that you've been able to provide some of your valuable time for us this morning.
Very enjoyable, thanks, Ed.